Hi, I'm Josh Gablin. In this video, we're going to be looking at the first amended complaint against Lovo Inc. filed last week on September 25th, 2024. This was all taken from a live stream, and I've condensed down for you here so you don't have to listen to me reading it in real time. If you like that sort of thing, make sure to subscribe so you can catch the next live stream. And if you like this one, make sure to subscribe to get the short versions in the future. I hope to hear from you in the comments below. We have Paul Lehrman and Linnea Sage on behalf of themselves and all others similarly situated, and John Doe and others similarly situated are the plaintiffs, versus Lovo Inc., the defendant. It was just filed September 25th, and we're here October 1st of 2024. So pretty recent here. What I have heard about this is that the new amended complaint has copyright infringement claims added. So we'll be taking a look at that today. I'll be reading the bulk of the complaint, but I'll be skipping some of the more boilerplate things like jurisdiction, for example. The nature of the action. Superstar Scarlett Johansson is not the only person whose voice has been used without permission. Whether her voice was tech cloned or imitated by an actor is not clear. We hear about senior citizens who receive voicemails supposedly from their grandchildren who say they are in trouble and need money wired to bail them out of jail. We have read about deepfakes of business people authorizing fraudulent payments, about union leaders supposedly urging members to vote against the very contracts they just negotiated, and even about the supposed President of the United States making phone calls about policy proposals that were completely fake and contrary to his actual positions. This case is about something even more basic, but no less sinister. It is about a tech company that has illegally cloned actors' voices and sold them to unsuspecting customers. As artificial intelligence, AI, generation proliferates content creation, so do concerns about its use. This is a class action brought on behalf of two voice actors, the plaintiffs Lehrman and Sage, and similarly situated persons whose voices and/or identities were stolen and used by Lovo to create millions of voice-over productions without permission or proper compensation. It is also on behalf of the John Doe plaintiff and other consumers of Lovo's voice cloning and text-to-speech service, who subscribed to the Lovo service thinking that they had the rights to use these voices for their projects, when in fact they did not. These actions by Lovo violate numerous state rights of privacy laws, federal copyright laws, state consumer protection laws, the federal Lanham Act, and are common law breaches of contract, unjust enrichment, and unfair competition. Take a break from reading this for a second to point out that they're throwing a lot here at the defendants to explain. We're looking at multiple state laws here. They're also going to be bringing the federal claims as well, though. It looks like we've got copyright infringement and trademark infringement. I think the trademark infringement might be new. I'm not sure. We've also got some common law things as well. Keep in mind the state laws in question are going to be New York. Let's get back into it. Lovo is a technology company with proprietary software driven by AI that allows Lovo's clients to create and edit voiceover narrations adapted from real actors. To be clear, the product that customers purchase from Lovo is stolen property. The voices are stolen by Lovo and marketed by Lovo under false pretenses. Lovo represents that it has the legal right to market these voices and use them commercially, but it does not. What are we talking about here? We're talking about generative AI. We're saying that this company, Lovo, took these voice actors' works and used them for training, for AI generative software. Background. The voiceover industry is estimated to generate more than $2 billion annually in the United States and more than $4 billion annually worldwide. Voiceovers, commonly known as narrations, are integral to various industries, spanning entertainment, advertising, marketing, education, and other corporate sectors. They serve as indispensable tools across a wide array of mediums, including film and television, commercials, animation, audiobooks, e-learning, corporate presentations, marketing presentations, educational videos. The list goes on for quite a while. I'm going to cut this down here to the end. They are even used in venture capital funding pitches. Traditionally, actors are hired to read scripts, which may be recorded in production house studios or with the actor's own equipment. The recordings are then edited, changes or re-recordings are produced, and a final recording is laid into the show or presentation. The actors are paid a negotiated amount for the use of their voices, and typically for the time spent recording the requested audio. The negotiated amount is a function of the actor's name, brand value, where and in what medium the voiceover will be used, and for how long it will be used. Payments typically include upfront fees, royalties, residuals, and some combination of these payments. And there are other potential fees required under SAG-AFTRA contracts. Actors like the voice actor plaintiffs get paid anywhere from $150 for a short recording, for a local television tag, to $2,000 for a one-time sales presentation, to a minimum of $6,000 for a 13-week run of a TV commercial, or more depending on the project. Established actors can make much more via residuals and through daily fees, which can exceed $1,000 per day and can involve several weeks of work. Failure to pay an actor a negotiated and agreed upon price for their professional services and often recognizable voice violates multiple state and federal statutes and common law. Defendant Lovo, by its own admission, is attempting to disrupt and revolutionize this traditional motto. Lovo sells a text-to-speech subscription service that allows its clients to generate voiceover narrations at a fraction of the cost of the traditional model. Lovo does this by allowing subscribing customers to upload a script into its AI-driven software known as Generative, or Jenny. I like that. Jenny with a G. And generate a professional quality voiceover based on certain criteria. For example, Lovo customers can choose between and designate their preference for male or female voices, regional accents, and older or younger sounding voices. Lovo has claimed that its generator, Jenny, was created using thousands of voices. Some of those voices were used by Lovo in violation of contracts between the artists, like plaintiffs Lehrman and Sage, and Lovo. Some voices may have been used with permission, other voices may have been scraped from public domain sources on the internet, and still other voices have been synthesized by Lovo's AI-driven software. Alright, so this is interesting. So now we're getting a little glimpse into the class that they're talking about. What is the class that they're claiming? The plaintiffs here have contracts, is what they're saying. But they're saying there may be other people that they used it with permission and may have been synthesized. We're seeing a lot of people trying to bring class action lawsuits. They're having difficulty getting to the class action certification, is what they call it. So in order for you to bring a class action, you need to have it certified by the court as a class. The class needs to be certified. So let's see how clearly they can define their class here. What is clear is that the voice actor plaintiffs' voices were cloned without permission or compensation. Lovo and its senior management often bragged about their ability to clone voices. According to Lovo, voice cloning refers to a virtual copy of a real person's voice. Rather than using machine learning to synthesize an original AI voice, voice cloning technology replicates an existing human voice. Tom Lee, CEO and co-founder of Lovo, remarked on a podcast how close the voice clones are to a real voice. I would like to say 100%, but that would be lying. We've had customers, one customer, his wife gave it 9.5 out of 10, but it's a validation of how close we actually got to cloning his original voice. Lovo did so in various forms of advertising to promote the sale of its subscription service, the very essence of its trade. For example, on January 17th, 2020, Lovo posted on its YouTube site, Lovo, Love Your Voice, a video with an explanation. In this video, you will hear 5 speakers whose voices have been cloned to near perfection. Their tone, accent, and even mannerisms are fully learned by our AI voice system. One of those voices was Plaintiff Sage's voice, which Lovo marketed with the pseudonym Sally Coleman. According to co-founder and CEO Charlie Choi, in little over a year, Lovo users created over 5 million voice content on the platform. Don't like the pluralization there, but that's all right. As of January 2023, Lovo claimed that its generator had been used by customers to create over 7 million voiceovers. There we go. And today, Lovo claims over 2 million customers. Mr. Lee explained on a January 2023 podcast how Lovo's synthetic speech platform works. Imagine that you have a real human voice, and we take that and clone that and make it available as an option for you to turn any text that you have into that voice. So you can make that voice say anything that you want, even if that person has never actually said that before in their life. On that podcast, Mr. Lee then stated that Lovo only needs a person to read 50 sentences. We can capture the tone, the character, the style, the phonemes, and if you have an accent, we can capture that as well. Lovo promotes a service using barely disguised images and names of celebrities and states on its website, clone any voice. So this seems to be the copyright issues as well, right? I mean, if they don't have the rights, you have a real human voice, and we take that and clone that. That sounds like copying to me. That sounds like just a different way of saying we copy it. And if they don't have the rights to doing that, then that sounds like it could be copyright infringement there. It could be pretty easy to use the defendant's words against them for at least that claim. All right, the benefit to a subscriber of using Lovo's service is financial. They do not have to pay the actor for a studio session, any residuals, royalties, or fees. They only pay a monthly subscription fee to Lovo. Subscribers also do not need to seek the consent of the actor, meaning actors lose control of how their voices are used. Implicit in Lovo's offerings to its customers is that each voiceover actor has agreed to Lovo's terms and conditions for customers to be able to access that actor's voice. But for the voice actor plaintiffs and other members of the voice actor class who have not agreed to Lovo's terms, the continued unauthorized use of their voices is theft of service and misappropriation. Lovo also implies to its customers that because the voiceover actors have agreed to use of their voices are available at a bargain, and customers can save on professional recordings by using Lovo instead. Indeed, the Lovo website boasts that customers can save $2 and time on voiceovers. And they have a screenshot right here. And we have another one here. Start saving 90% of your time and budget today. On its website, Lovo represents to potential clients that it respects the rights of voice actors, implying it has agreements with actors allowing Lovo to utilize those actors' voices and compensating them appropriately for that use. That may be true with respect to some actors, but it is emphatically not true with respect to the voice actor plaintiffs. Lovo had no permission to use voice actor plaintiffs' copyright-protected recordings, i.e. their voices, for training its AI generator. To promote the Lovo service, or to market voices based on the voice actor plaintiffs' voices. To be clear, Lovo never compensated the voice actor plaintiffs for any of Lovo's unauthorized use of their voices. So, there they spell it out. They have the copyright here. They're saying copyright protected recordings in their voices. They're making money off of us here, and we want that money. We deserve that money. Saw they had a Lanham Act claim above. That's the Trademark Act, the Federal Trademark Act for the U.S. So if they're doing that, there are provisions in the Lanham Act where they can potentially get the profits that they made. So that's something that they might be going for by saying that these people are making money. Lovo is taking money. Lovo is profiting here. And they would say that they're entitled to those as lost profits. Upon information and belief, Lovo has not entered into any agreement with SAG-AFTRA pertaining to the employment of its members for voice actor services. Those agreements are designed to protect the rights of SAG-AFTRA members who are required by SAG-AFTRA's Global Rule 1 to eschew jobs that are not covered by the union's contract. Lovo represents to its customers that Lovo is granting full commercial rights for all content generated using its platform to users who subscribe to any of its paid plans. Lovo advertises to clients and prospective clients that when they purchase a subscription to Lovo's services, they are purchasing the commercial rights to use the cloned voices. As explained in Lovo's terms of service, commercial means to include any monetized business-related uses such as videos, audiobooks, etc. Yet Lovo does not legally own or control the rights of voice actor plaintiffs' voices it is purporting to give these customers, rights which remain with the actors whose voices have been illegally cloned or otherwise misappropriated. This makes me think of there's something inducing people to engage in infringement can itself be a cause of action for infringement. It's kind of like a type of third-party infringement, but you're only committing copyright infringement because someone else is telling you to, because I am telling you to do it. Then I bear some responsibility under the law for that. A little bit more complicated than that. There are definitely specifics to it, but that might be what they are getting at here. Defendants' misappropriation of the voice actor plaintiffs' voices. Voice actor plaintiffs' voices are unique, distinctive, and of professional quality, which is why Lovo sought them out to teach Jenny and create AI copies or clones. Voice actor plaintiffs specialize in voiceover services, particularly in the fields of radio and TV commercials, explainer videos, e-learning, IVR, and voicemail, and corporate narration, the same fields for which one might use Lovo's services. Voice actor plaintiffs' work has been sought out by large companies, including Uber, McDonald's, JP Morgan, American Red Cross, Disney, Starbucks, Twitter, Airbnb, and Volkswagen. Mr. Lehrman's work has included acting work on Blue Bloods, New Amsterdam, The Resident, Bull, an HBO movie, and 2 supporting roles in major motion pictures. You don't want to tell us what the HBO movie and the supporting roles in motion pictures are. Miss Sage has done voiceover work for companies such as Febreze, Starbucks, Twitter, Audible, McDonald's, and Staples, on international TV, radio, and online, as well as in the Marvel Avengers Academy video game and Marvel Snap, a digital collectible card game. Plaintiff Sage is also the host of the app Slotomania, which is a mobile game played by 70 million people worldwide, as well as a series regular on the podcast Beef and Dairy Network with 40,000 monthly listeners. Both voice actor plaintiffs have professional reputations to be protected and are consistently careful with which products, clients, and positions they support and endorse. Fiverr.com is an online marketplace that connects freelancers with clients looking for digital and creative services. In May 2020, Mr. Lehrman was contacted via the Fiverr website by someone identified as user a long string of numbers, later identified by Lovo's counsel as a Lovo employee who wanted Mr. Lehrman to provide voice recordings for research purposes. Using the Fiverr platform, Mr. Lehrman communicated about the inquiry with the apparently not a spam user. On multiple occasions in communications with Mr. Lehrman via Fiverr, the user and Lovo represented that the audio recordings would not be used publicly. On May 10th, 2020, Mr. Lehrman was assured that his recording would be used for internal research purposes only. The user repeatedly assured Mr. Lehrman that the files would be used for internal research purposes from the initial order request until Mr. Lehrman agreed to upload his voice. On May 12th, 2020, before Mr. Lehrman agreed to upload the voice files requested, he asked, "In addition, can you please explain how the voiceovers will be used?" Later that day, the user responds, "We are researching speech synthesis with different accents and voices. Your voiceover will be used for academic research purposes only." This sounds so shady. Mr. Lehrman wrote back, "Great, still working through the scripts. Please guarantee that these scripts will not be used for anything other than your specific research project. My curiosity is getting the best of me. What is the goal of the research project? The scripts will not be used for anything else, and I can't tell you the goal as it's confidential work in process. Sorry, haha." That's Lovo. Sorry, haha. Mr. Lehrman responded to the user, "That's okay. Will my voice be repurposed and used in a different order?" To which the user wrote, "The script and your finished file will be used for research purposes only." Only after receiving these reassurances and after reaching this understanding with the user, Mr. Lehrman delivered the requested audio files of his voice, 104 recordings in total, to Lovo via Fiverr. Mr. Lehrman was paid $1,200 by Lovo for the recordings, and Mr. Lehrman subsequently registered these audio files with the U.S. Copyright Office and received 2 registration numbers for these audio recordings. Part of why this is an amended complaint and why they're bringing the copyright claims now is you can file for registration. I have another video where I say this. You can file for registration after litigation has begun, but as soon as you get to court, they're going to want proof that you have the copyright, and they're going to want that in the form of a registration. So it's always a good idea to get that done before you need to worry about a lawsuit. And if you can't, then it just becomes much more expensive. So now here we're looking at the amended complaint, and this has all of the copyright information here, which is good, which is exactly what you want to be able to show the court. If you're saying somebody infringed on your copyright, you want to be able to say this is exactly what they infringed upon. Effective date of registration, June 24th, and registration decision date. Oh, here we go. Decision date of August 16th and decision date of August 26th. So it does seem to be why they were waiting here. I'll give a little shout out again. I'm reading this off of ChatGPT is eatingtheworld.com. We have Edward Lee is a scholar in this area, and he is hosting this PDF. So thank you for hosting this PDF for us and for your analysis, and it seems to support that they were waiting to file the amended complaint for the copyright registrations. In 2020, at the time of the online communications between Mr. Lehrman and the user, neither Mr. Lehrman nor Ms. Sage had any idea what speech synthesis was. Mr. Lehrman had no reason not to believe the user's assurances that his voice would be used for academic research purposes only. At no time did the user, that is, Lovo, ever accurately represent that Mr. Lehrman's voice would be used for anything other than academic research purposes. Mr. Lehrman, a professional voice actor, understood academic research purposes to mean analyzing such qualities as pitch, loudness, tone, timbre, cadence, inflection, breathiness, roughness, strain, jitter, variation in pitch, shimmer, that is variation in amplitude, spectral tilt, and overall intelligibility. Spectral tilt. I ran a record label for about a decade, and I don't think I ever heard the word spectral tilt before, but I like it. Such research is essential in helping people with hearing deficiencies hear better. Okay, so maybe it's more of a hearing aid thing than a music thing. The user, that is Lovo, never told or implied to Mr. Lehrman that his voice would be used to train Jenny, their generative AI, that it would be cloned, that it would be provided, sold, or licensed to subscribers of Lovo's service, that it would be used and sold or licensed by Lovo under the name Kyle Snow, that it would be used as a default voice by Lovo, that it would be used by Lovo in advertising, that it would be used in trade, or that it would be used for commercial purposes. Had Mr. Lehrman known any of that, he would not have agreed to provide the audio files to the user or Lovo. Mr. Lehrman never gave Lovo permission to use his voice or copyrighted audio recordings to train Jenny. So, give me $1,200 and I'll give you my voice recordings. Now, can you explain how these will be used? He's saying academic research purposes only. They might have breached the contract just by saying they were only going to use it for academic research purposes. You know, perhaps the development of the software, sure, but the commercial use doesn't seem to be academic. Mr. Lehrman declined to participate in other AI projects. On March 28, 2022, a Fiverr executive asked Mr. Lehrman if he would like to add an AI software option to his Fiverr profile that told Mr. Lehrman that the AI software option would integrate with his profile and allow customers to hear what Mr. Lehrman's voice could sound like if he were to read a script. Mr. Lehrman declined the invitation to add that AI software to his Fiverr profile. Mr. Lehrman demonstrated to Fiverr that a user could easily produce commercial audio without consent or compensation, as well as create violent, pornographic, or any unauthorized audio material without consent from the voice actor. Mr. Lehrman and Miss Sage hear Mr. Lehrman's cloned voice and discover Lovo is behind it. On July 11th, 2023, as Mr. Lehrman and Miss Sage were driving in their car, they were listening to the June 20, 2023 episode of the Deadline Strike Talk podcast, hosted by Billy Ray. Ironically, the episode was about the dangers of AI technologies. In fact, it was a conversation with Poe, an AI bot. It became immediately clear that the voice of Poe was, in fact, Mr. Lehrman's voice. The Deadline Strike Talk podcast that used Mr. Lehrman's voice was produced in cooperation with MIT professor Simon Johnson. The host, Billy Ray, asked questions of Professor Johnson, who typed those questions into ChatGPT. When the answers came back from ChatGPT, Professor Johnson entered that text into Lovo's software, which answered the questions orally in Plaintiff Lehrman's voice. When plaintiffs Lehrman and Sage's counsel sent an inquiry to Professor Johnson about how the oral answers were produced, Claire Schneider of MIT's Office of General Counsel responded on September 29, 2023. Professor Simon's team utilized a paid subscription to Lovo as part of the creation of the project that was featured on the podcast to which you refer. The podcast was first produced and first aired on June 20th, 2023. There's no question that the voice used on the Deadline Strike Talk podcast was identical to Mr. Lehrman's voice. Confusion with Mr. Lehrman's real voice and brand. Numerous people who heard the podcast and who were friends or professional colleagues of Mr. Lehrman or Miss Sage told Mr. Lehrman or Miss Sage that the Poe voice on the podcast was virtually identical to Mr. Lehrman's voice. They told Mr. Lehrman and Miss Sage that the cloned voice would undoubtedly be mistaken for Mr. Lehrman's actual voice, causing real confusion and harming Mr. Lehrman's brand. As described below, Lovo's counsel has admitted that the original voice recording for Kyle Snow was provided to Lovo for a fee by a freelance voice artist on Fiverr.com, then used to create the fictitious characters. As described below, Lovo subsequently used Mr. Lehrman's cloned voice as its default voice for its subscription service, used it to advertise Lovo's service, and marketed it under the name Kyle Snow. These unauthorized, uncompensated uses caused confusion and harm to Mr. Lehrman and his brand in the marketplace. It is not Mr. Lehrman alone who believes that the Deadline Strike Talk podcast Poe is identical to his voice, or that Lovo's Kyle Snow character is using Mr. Lehrman's cloned voice. As the unattached, unsworn declarations attest, casting agents, producers, professional television and radio journalists, and other actors say so too. Alright, so what I think they're going for here is consumer confusion. They're trying to say it causing real confusion and harming Mr. Lehrman's brand. And this could go towards a couple things, but I think that this is relevant to the Lanham Act claims that they mentioned earlier. It goes on, when CNN correspondent Claire Duffy listened to the side-by-side comparison of Mr. Lehrman's real voice and the Lovo cloned voice, she reported, "Obviously, this does sound a lot like you." When ABC Australia radio reporter Julianne Morrow listened to the side-by-side comparison of Mr. Lehrman's real voice and the Lovo cloned voice, he reported, "Paul, I've listened to the comparison of what does very much sound like your voice." Interesting way to say that. Plaintiff Sage's contract with Lovo. On October 29th, 2019, Plaintiff Sage received a message on the Fiverr platform from TOMLSG, we'll shorten that to Tom, offering her a contract to produce and record test scripts for radio ads. Before accepting the job offer, Miss Sage asked what the voice recording would be used for. The response on the Fiverr platform from Tom was, "These are test scripts for radio ads. They will not be disclosed externally and will only be consumed internally, so will not require rights of any sort." Miss Sage accepted the job. Before providing the audio files, however, Miss Sage confirmed that if the user were to place the order and later down the line use them in broadcast, "I hope that you will come back and order the appropriate licensing." She was assured by the user, Tom LSG, that these are test scripts for radio ads. They will not be disclosed externally. Will only be consumed internally, so will not require rights of any sort. Yeah, so they're saying in this one that these are test scripts for radio ads. So for them to argue that they didn't breach either of the contract, they're going to need to say that they were test scripts from radio ads and that they were only used for academic purposes. Only after this reassurance and reaching this understanding, Miss Sage delivered the audio recordings to Lovo. Miss Sage was paid $400 for the job by Lovo. The Fiverr user Tom LSG was Lovo co-founder Tom Lee. Well, we got your name right, Tom. Wonder what the SG stands for, though. Miss Sage subsequently registered the audio file she delivered to Lovo with the U.S. Copyright Office and received registration number for 10 audio tracks. Here we go. And a little bit sooner, but we can see this is still pretty recent, June 18th, decision date of July 15th. So these copyrights did just come in 2 months ago, less, and it looks like they were working on this that whole time. Defendant wrote a glowing review of Miss Sage's voice on Fiverr and stated regarding Miss Sage's voice that stellar is an understatement. We would recommend her to anyone. Some years later, in July of 2023, after hearing Mr. Lehrman's voice on the Deadline Strike Talk podcast, Miss Sage discovered that Lovo had been using, manipulating, and editing her voice in multiple promotional and commercial ways for many years without her permission or compensation. Miss Sage learned that in 2020, Lovo used both a recording of her actual voice, the copyrighted audio sample she provided to Lovo in October 2019, and a cloned version of her voice with the identical content that she recorded for Lovo to raise money from investors and to promote the service to potential customers. Lovo used this side-by-side presentation at the Berkeley Skydeck Demo Day Spring 2020 event and, upon information and belief, on subsequent dates to raise money from investors. Lovo also pointed the presentation publicly to YouTube. This side-by-side comparison of Miss Sage's voice, the recording she made for Lovo in November 2019, and the generated script of the identical content utilized Miss Sage's copyrighted recording. Lovo used the copyright recording not only without permission, but in direct contravention to Lovo's previous assurances that Miss Sage's voice would not be used public. The Skydeck Demo Day event and the subsequent usage were uses in trade, were advertising / commercial uses that were instrumental in helping raise money for Lovo. Pictures here too, and it looks like they have links to YouTube videos as well here. We are on ChatGPT's eatingtheworld.com, where Edward Lee gives updates on these things, and he is hosting this PDF. So if you want to see these yourself, which I think this next section might be best watched, you can check these YouTube videos out yourself. As Love's co-founder and CEO explained, if you are doing a voiceover for one project, you can't be doing narration for something else at the same time. But with Lovo, an actor could have his voice reproduced and used in multiple projects, and it is practically indistinguishable from the real voice. This makes the human voice truly scalable. Making humanity scalable. Indeed, even though it is obvious, Lovo has admitted that Plaintiff Sage's voice was a clone. On a video posted in January 17, 2020, and still available on May 21st, 2021, Lovo wrote, "In this video, you will hear 5 speakers whose voices have been cloned to near perfection. Their tone, accent, and even mannerisms are fully learned by our AI voice system." Miss Sage never authorized Lovo to market her cloned voice under the name Sally Coleman. Lovo raised millions of dollars in venture capital using Miss Sage's copyrighted audio recordings, that is her voice, in unauthorized and uncompensated presentations to showcase the Lovo technology. Lovo used Plaintiff Sage's copyrighted audio recording without permission to advertise and promote their services. Alright, so I think advertising and promoting are key here. It might go towards the Lanham Act claims, but I think these also go towards the state claims. We're going to see those spelled out here. It is not Miss Sage alone who believes that Lovo's Sally Coleman character is using her cloned voice. As described below, Lovo's counsel has admitted that the original voice recording for Sally Coleman was provided to Lovo for a fee by a freelance voice artist on Fiverr.com. Regular people on the street are also fooled by the cloned voice. As stated in a comment on the CBS News YouTube channel, "Wow, the recording and speech with the woman sound exactly the same. Yes, rules are needed ASAP, like yesterday." Another user commented, "They sound exactly the same." It's interesting. They quote the comments on a CBS News YouTube channel first. But then, unlike Mr. Lehrman, where they say professional reporters. Then they, after the comments, after these comments by user NM3547, I don't know, maybe that's a famous user. I am not familiar. CBS News correspondent Joe Ling Kent, who listened to the side-by-side comparisons of Miss Sage's real voice and the Lovo cloned voice and reported on CBS Mornings, it feels exactly the same. That I would put that first. As the unattached, unsworn declarations attest, casting agents and all of these other professionals agree that Lovo's cloned voice is a replica of Miss Sage's real voice. In July of 2023, Mr. Lehrman began investigating whether his voice had been used by Lovo or anyone else. Mr. Lehrman learned that Lovo had used his voice in multiple ways, including advertising and trade, without his consent and without compensation for that use. Lovo used Mr. Lehrman's voice to promote and advertise its Jenny service without Mr. Lehrman's permission and without compensating him. The ads Lovo put on its website and YouTube used Mr. Lehrman's cloned voice and are still available. So ongoing damages is what I'm seeing here. If they are still advertising using it, there might be some relief that they would seek to stop it now. So I don't know if they are seeking preliminary injunction is what it would be. Mr. Lehrman never gave Lovo permission to use his voice to advertise and market the capabilities of the Lovo software. Mr. Lehrman learned that Lovo had been marketing his misappropriated voice as part of its subscription service under the stage name Kyle Snow. The Kyle Snow voice was unquestionably Mr. Lehrman's voice. Lovo cloned, sold, and licensed Mr. Lehrman's voice under the moniker Kyle Snow without Mr. Lehrman's consent and without compensating him, and used Mr. Lehrman's voice to train its Jenny generator without Mr. Lehrman's consent and without compensating him. Mr. Lehrman and Miss Sage sent a cease and desist demand letter to Lovo. On August 18th, 2023, prior counsel for Mr. Lehrman and Miss Sage sent a letter to Lovo. In that letter, counsel demanded that Lovo cease and desist from using or marketing Mr. Lehrman's and Miss Sage's voices, including marketing their voices under the names Kyle Snow and Sally Coleman. On August 2023, in a response to a cease and desist letter sent to Lovo's counsel on August 18th, Lovo counsel admitted that the original voice recording for Kyle Snow and Sally Coleman were provided to Lovo for a fee by freelance voice or artists on Fiverr.com in 2020 and 2019 respectively. Lovo then used these voice recordings to create the fictitious characters. Lovo obtained the original voice recordings for Kyle Snow and Sally Coleman from a male and female freelancer on Fiverr. The freelancer that provided audio file for Kyle Snow used the handle Paul Sky with an E, and the freelancer that provided the data file for Sally Coleman used the handle Linnaeus8. That makes it a little bit easier. Now they're able to draw a line because Lovo's counsel said Kyle Snow, Paul Sky, Sally Coleman, Linnaeus8. And all they need to do is prove that they were working using those handles and saying, yeah, I was Paul Sky at that time. I was Linnaeus8 at that time. Let's read the rest here. Lovo's counsel stated, the voice recordings used by Lovo are not unauthorized recordings of your client's voice recordings. The voice recordings provided to Lovo were created and authorized by those freelancers using their own voices specifically for Lovo. Lovo provided an original script for the freelancers to read. Each freelancer then read the script and provided an original audio file to Lovo. As such, the voice recording used by Lovo to create Kyle Snow and Sally Coleman were fully permissioned and provided by the individual whose voice appears in the audio file. They're saying, actually, we have the rights the whole time, which is going to be a difficult argument to make if we don't have anything beyond the text messages that we've seen here, where they're claiming some inconsistent things. They're saying, if we go back to, remember, Mr. Lehrman, they're saying it was for academic purposes, research purposes, and for Miss Sage, they were saying that it would be used for radio tests. At the time Lovo procured their voices on Fiverr, Lovo had obscured the fact that it was an AI voice generation company that was ordering from Lehrman and Sage. Lovo's counsel also admitted the original voice recording for Kyle Snow and Sally Coleman were provided to Lovo for a fee by freelance voice artists on Fiverr.com in 2020 and 2019 respectively. Lovo then used these voice recordings to create the fictitious characters. Paul Sky is the Fiverr identity for Mr. Lehrman, and Linnaeus88 is the Fiverr identity for Miss Sage. Might be a typo here, right, with Linnaeus 8, Linnaeus 88. Footnote at the bottom here. On September 27th, 2023, plaintiffs responded to Lovo's counsel. As of October 2nd, 2023, Plaintiff Lehrman's voice was still available as the voice of Kyle Snow on the Lovo website. And on October 11th, 2023, Lovo's counsel responded that Lovo had taken down other uses of Kyle Snow and Sally Coleman's voices, yet even as of November 28th, Plaintiff Lehrman's voice was available as the voice of Kyle Snow. Lovo's counsel further stated, as such, the original voice recordings that became Kyle Snow and Sally Coleman on the Lovo site were fully permissioned, authorized, and compensated. That is not so. Lovo assured both Lehrman and Sage that the recordings would not be used externally. Lovo's counsel added, nevertheless, Kyle Snow or Sally Coleman are not popular and sales are negligible. To avoid any further misunderstanding, Lovo unilaterally removed the characters. So they're saying, you want us to take it down? Fine, we don't even want it. You're not popular and your sales are negligible. Seems like a little bit of shade that the council is throwing back there, when they could have just said, to avoid further misunderstanding, we'll remove the characters. Mr. Lehrman's and Miss Sage's voices were instrumental in Lovo's fundraising and commercial success. Contrary to the Lovo Council's assertion, Mr. Lehrman's Kyle Snow character was, according to Lovo, the fourth best voice on the Lovo site and the default voice that Lovo provided to subscribers. Lovo used Mrs. Sage's voice to raise millions of dollars of venture capital. Lovo used, marketed, and advertised Mr. Lehrman's voice under an identity Lovo created called Kyle Snow for purposes of trade and without permission or compensation. Lovo used, marketed, and advertised Miss Sage's voice under an identity Lovo created called Sally Coleman for purposes of trade and without permission or compensation. On July 10th, 2023, Lovo published an article promoting Lovo's services on its website titled 5 Best Practices for Perfect Audio Advertising that featured Mr. Lehrman's voice and attributed that voice to Kyle. And I think we have a link to it down here. Again, it is all linked to in their complaint. On June 21st, 2023, Lovo also promoted Mr. Lehrman's voice as Kyle Snow and said it was one of the 5 best male voices for text-to-speech. The Lovo promotional piece continued. With his upbeat tone and slightly faster talking speed, Kyle Snow has the perfect voice for conveying enthusiasm and youthfulness. This makes him an ideal male voice generator, text-to-speech option for all kinds of content, from audiobooks and narrations to commercials and social media. His upbeat tone becomes even more enthusiastic and compelling if you speed up his voice, while his tone remains cheerful and enthusiastic, but takes on a clearer, more pronounced quality when slowed down. This makes Kyle's decelerated voice an excellent choice for explainers and e-learning. So that's just, they just throw in a bit of ad material here where they're really trying to sell this guy's voice. They're immediately rebutting this claim in the cease and desist here. Kyle Snow or Sally Coleman are not popular and sales are negligible. To avoid any further misunderstanding, they remove the characters. And here they're saying, we actually don't believe you on that, and they're probably going to be asking for that proof. Mr. Lehrman later learned that from 2021 to September 2023, his voice was the default voice for the software. In other words, when somebody started to use Jenny, it was automatically set to Kyle Snow, that is, Mr. Lehrman's voice. It is unknown how many of the 7 million voiceover projects Lovo claims were made with Jenny using Kyle Snow or default voices. Lovo boasts that it offers 500 plus voice options. Lovo stated that Mr. Lehrman's Kyle Snow voice was listed 4th on the Best Voices platform. You saw that image above. And here they're doing a little bit of math. If Mr. Lehrman's voice was used in 1/500th of the 7 million projects Lovo claims were created, that would mean Mr. Lehrman's voice was used in some 14,000 projects. They're saying, we'd like to see those receipts, please, if you're saying that actually you didn't make any money off of his voice. To avoid any misunderstanding, Lovo said they unilaterally removed the characters. That was not true. Lovo either failed to remove or subsequently republished both the Kyle Snow and Sally Coleman voices on its website, advertised them on its YouTube channel, and continued to make them available to customers who had previously created projects with their voices. For example, the Kyle Snow voice was still available as of September 23rd, 2023. And we have a screenshot here. Screenshot with Kyle Snow right in the middle here. American English, Young Adult, Education. Just as the use of the Lovo software on the Deadline Strike Talk podcast was within 1 year of plaintiffs filing this action, these new publications were also within 1 year of the filing date. Further, Mr. Lehrman's voice was used on multiple Lovo tutorials. So here they have some screenshots of the tutorials, choosing the perfect TTS voice for your content, TTS text to speech. And we can see here Kyle. And you can use, they're saying Kyle, you can make something with Kyle Snow's, rather Mr. Lehrman's voice. And if it really is 5 steps, then that seems like it would be, going back to what I was saying earlier about inducing someone else, they're bringing the customers in on this as well. And we haven't quite we haven't seen as much about the John Doe customer plaintiff class yet. It could go towards a form of infringement to encourage and induce other people to infringe. And I'm not sure that they're actually going to be going with that claim here, but that's just something that comes to mind when you see 5 easy steps on their website to use this clone of Mr. Lehrman's voice. Mr. Lehrman never authorized Lovo to use, clone, manipulate, or repurpose his voice for Lovo's service or any other use. He did not authorize his copyrighted voice to be used to train Jenny. He did not authorize Lovo to use his voice in an API, nor did Mr. Lehrman authorize Lovo to connect his voice to the stage name Kyle Snow, sell it to subscribers, or use it in advertising. Mr. Lehrman was never made aware of nor compensated for defendants' unauthorized usage of his voice. Lovo's scheme not only unlawfully appropriated, used, sold, and marketed Mr. Lehrman's voice, but it interfered with his ability to earn a living. Lovo knew that its scheme could threaten Mr. Lehrman's relationship with producers, casting agents, SAG-AFTRA, and those producers' signatories. We know that they are trying to disrupt this market. That's one of the things that we can kind of tell with these claims is, look at how easy it is for you to do this without hiring Mr. Lehrman or someone who is in, let's say, maybe Mr. Lehrman's class. Similarly situated plaintiff might be unable to earn a living because Lovo is attempting to disrupt the market. But in the way that they're doing it, it seems like they might be trying to use Mr. Lehrman's voice to make that happen to him. Defendant's improper use of Plaintiff Sage's voice. Plaintiff Sage subsequently learned that her voice was marketed by Lovo as part of its subscription business. Lovo promoted the availability of Miss Sage's voice under the name Sally Coleman. Lovo also used Miss Sage's voice on its website to demonstrate the software capabilities and to advertise and promote its business. Miss Sage never gave Lovo permission to use her voice to advertise and market the capabilities of the Lovo software. She never gave Lovo permission to clone or use her voice as part of its subscription business, permission to use her voice or copyrighted audio recordings for marketing purposes, or to use her voice or copyrighted recordings to train Jenny, the generative AI. Miss Sage was never compensated for Lovo's improper use of her voice. Remember, Miss Sage only got $400 out of this, and Mr. Lehrman got $1,200, so make of that what you will for this company. And they were also told very different things as well about how their material would be used. Defendants' unauthorized use of Lehrman and Sage's voices continues. Significantly, despite assurances of Lovo's counsel that Plaintiff Lehrman's voice, denoted as the voice of Kyle Snow, had been removed, and Lovo's informing users that Kyle Snow voice had been retired, Mr. Lehrman's cloned voice is still live on Lovo's YouTube page as an advertisement for Jenny and under Community Originals. Despite assurances that the characters would be removed, as of August 2024, Ms. Sage's voice was still available as Sally Coleman on Lovo's application programming interface, or API. APIs are published online and shared freely. They are application programming interfaces that are publicly available to software developers. Lovo explains what an API is in this way. I'm not going to read their definition of AI, but I will start here. In the context of Lovo and Jenny API, here's how it works in simple terms. Lovo and Jenny are text-to-speech services that can turn text into spoken audio. Their APIs act as intermediaries, allowing your application to request voice generation without you having to understand all the complex processes happening behind the scenes. If you want to know more about AIs, legal filing is not the place to, I would say, to learn about software development. All right, here's that 5-star review from Tom Lee from earlier. Tom Lee SG gave her a 5-star review on Fiverr. Miss Sage's and Mr. Lehrman's voices were still available to new customers through the end of September 2023. In September 2023, approximately 10 days after plaintiff's cease and desist letter was sent to defendant, Lovo sent an August newsletter to customers. Lovo announced to its users that it would take down the voice actor plaintiff's voices, that is, Kyle Snow and Sally Coleman. But Lovo misrepresented the reasons it was doing so. Lovo said that the voices of Kyle Snow and Sally Coleman and 11 others were being retired as their licenses were expiring. Lovo acknowledged that this might be disappointing bad news to hear, as their licenses were expiring. Alright, so let's talk about the business side of here. If you're Lovo, you want to have your story straight, because you're saying that you have the rights to it and that you were authorized to use these, but now you're saying that the licenses are expiring as well, which is not the same thing, and definitely was not negotiated or reflected in at least anything that we've seen in the contract or negotiations so far. From Lovo, the messages to Mr. Lehrman and Miss Sage over Fiverr did not have a time limit. They did not appear to have any sort of license to use this. To be clear, Lovo never had a license with Mr. Lehrman or Miss Sage. There was no license to expire. Contrary to Lovo's assertion that the Kyle Snow and Sally Coleman's voices were being retired, those voices remained available on the Lovo website and Jenny for almost a month. Indeed, after Lovo stated that plaintiff's voices had been taken down, plaintiff Lehrman's voice was still available as the default voice on the Lovo website. On January 20th, 2023, Lovo put plaintiff Lehrman's voice in an advertisement. That advertisement is still available on Lovo's YouTube page and seen as a tutorial video uploaded as of July 19th, 2023. Defendant recognizes the improper usage of plaintiff's voices. Ironically, Lovo's CEO Tom Lee recognized the threat of improper usage of AI-generated voices. In 2019, co-founder Lee wrote in an article for Medium, "Some people are alarmed by the possibility of their voices being used unbeknownst to them or in malicious, illegal ways. Others are concerned they are going to take away the jobs. While they are right to be concerned, it shouldn't be a divisive confrontation. Just like how we must be wary of our images, names, affiliations, and identities are used by ourselves or others, we must ensure that our laws and ethics develop in step with the technology to create a safe environment." It certainly seems inconsistent with what they're doing. Say the law and ethics are on your side when they did not seem to have valid contracts that gave licensing rights to these things, like they're claiming that they did. All right, let's skip down here to the actual causes of action. First cause of action, violation of New York Civil Rights Law, Section 50 and 51. Section 50, person, firm, or corporation that uses for advertising purposes or for the purpose of trade the name, likeness, voice of any living person. Those privacy rights. And then this is going to be their cause of action here. May maintain an equitable action in the Supreme Court of this state against the person, firm, or corporation so using such person's name, portrait, picture, likeness, or voice, to prevent and restrain the use thereof. All right, let's see what the second cause of action here is. Deceptive acts and practices in violation of the New York Deceptive Practices Act. All right, this section imposes liability on anyone who engages in deceptive acts or practices in the conduct of any business, trade, or commerce, or in the furnishing of any service in New York. So another New York State cause of action where they're saying they engaged in a deceptive practice by, again, using their voice. Let's see here. Defendant has engaged in consumer-oriented conduct that has misled and harmed plaintiffs. Defendant misrepresented to the voice actor plaintiffs and class the purposes for which their voices would be used. Lovo told the voice actor plaintiffs and members of the voice actor class that their voices would be used only for academic research purposes and or not for public use. Lovo was not consistent in what they told the voice actors that they were getting these recordings from. Lovo then used their voices in ways that were not agreed to or permitted, and for which plaintiffs were not compensated. In the course of business, defendant made deceptive, affirmative misrepresentations and omissions to consumers by publishing and disseminating misleading information that the voice actor plaintiffs were affiliated with Lovo and had given their consent to be included in Lovo's product offerings. These misrepresentations and omissions alleged herein were materially misleading. All right, so they're saying deceptive acts again under this New York statute
false advertising in violation of the New York False Advertising Act. Let's see, this imposes liability on anyone who uses false advertising in the conduct of any business, trade, or commerce, or in the furnishing of any service in New York. False includes advertising, including labeling of a commodity, if such advertising is misleading in a material respect. Let's see here. YouTube is an advertising vehicle, no different from NBC, Fox News, or Hulu. Defendant has placed promotional videos on YouTube, including videos featuring Mr. Lehrman's voice as of January 20th, 2023, and Miss Sage's voice as of January 17th, 2020. Lovo used its YouTube channel with plaintiff Lehrman's voice to misrepresent the rights that consumers would receive by subscribing to the Lovo service. This is deceptive advertising, and the use of Mr. Lehrman's voice to deliver these false and fraudulent messages harmed his brand. The association of Mr. Lehrman's voice with Lovo's deceptive messages and deceptive business practices harms his brand. Deceptive advertising caused monetary and reputational harm to members of the voice actor class because clients use the recognizable voices for projects for which the actors do not get compensated. Like I said, I'm not a New York attorney, so I can't speak to how this will affect it. So we'll skip down here. We have another deceptive acts and practices. Someone, I'm sure there's a New York attorney out there who's happy to explain these in greater detail. We see these deceptive acts and practices on the fifth cause of action as well. Sixth cause of action, unfair competition and false affiliation in violation of Section 43 of the Lanham Act. This is what I've been talking about. So we're talking about false affiliation, unfair competition. That's what I wanted to say. So any person who uses in commerce any word, term, name, symbol, or device, or any combination thereof, a false designation of origin, etc., that is likely to cause confusion. Remember earlier when they said that it is likely to cause confusion between the voices. Mr. Lehrman's voice and Miss Sage's voice, when they showed those voices and the clones to reporters, different people in the field, professionals, producers, remember they have a huge list, they all said that there was a chance of confusion. And that's what we're getting to here, this likelihood to cause confusion or to cause mistake as to deceive affiliation, connection, or association. That's what they're getting at here. Also, we have in commercial advertising or promotion, if they're using Mr. Lehrman's voice there, then they're misrepresenting that as well. As described more fully herein, defendant has engaged in such conduct in the promotion of its Jenny product via defendant's website, its YouTube channel, and on podcast appearances and interviews. This conduct has caused and is likely to cause mistake and deception as to the affiliation, connection, or association of the voice actor plaintiffs and the other voice actor class members with Lovo. This is the crux of the unfair competition, false affiliation claim, confusion here. And they're going to go through a bunch of ways that they've done it. Confusing, or likely confusing, potential customers about the existence of any business affiliation between the voice actor plaintiffs and class members with Lenovo. Misrepresenting that the voice actor plaintiffs and class members have a consensual business partnership with Lovo and are part of its catalog of available voices. I think I said Lenovo, but a minute ago I meant to say Lovo. Number 3, misrepresenting that customers may use Lovo to directly purchase the voice actor plaintiff services. Failing to inform Lovo customers that the voice actor plaintiffs and the class members have not consented to offer their professional services through Lovo. Failing to inform Lovo customers that the Lovo subscription service cannot be used in place of other payment methods to pay for services provided by the voice actor plaintiffs and the class members. Harming the reputations of the voice actor plaintiffs and the class members by falsely affiliating with them. Harming the reputations by refusing to completely remove them from the Lovo website when they requested disaffiliation. Here, 8 ways that they say. This is number 8. Stealing potential customers from the voice actor plaintiffs and the class members by diverting them to purchase services from the Lovo subscription service rather than directly transact with the voice actor plaintiffs. This is the unfair competition claim. They're competing, and they're competing by stealing their voices, cloning their voices, and selling their voices to their clients, is what they're saying. False advertising is another claim under the Lanham Act here. I'm not going to go through all of these again, but it looks like they're alleging the same conduct as well. A lot of misrepresentation. Here we go. Failing to inform Lovo customers. Sorry, Lenovo. Failing to inform Lovo customers that the Lovo subscription service cannot be used to pay for the professional services of the voice actor plaintiffs and class members. Pretty similar claims under New York laws to deceptive advertising. We've got false advertising, false affiliation, and unfair competition. We have unjust enrichment here. This is probably going to play along the unfair competition claims. Defendant appropriated the voice actor plaintiffs and classes' voices without their permission and then marketed AI generated versions of their voices as part of defendant's business, receiving millions of dollars in revenue without ever properly compensating plaintiffs. Defendant also used the voice actor plaintiffs and classes' voices without permission or compensation to raise millions of dollars in venture capital. Defendant was unjustly enriched by depriving Lehrman, Sage, and the voice actor class of fees they would have been entitled to. Plaintiffs plead this count in the alternative to the breach of the contract cause of action below. Ninth one is unjust enrichment as well. They have a couple other things here as well. Cause of action for unjust enrichment. 10th cause of action, conversion. We have a claim for fraud. Defendant Lovo committed fraud by material misrepresenting to plaintiffs Lehrman and Sage and other members of the voice actor class what would be the ultimate uses of their voiceover recordings. Lovo omitted to tell the voice actor plaintiffs that their voice recordings would be used for promotion of Lovo's services and as available voice options on Lovo's website. Defendant knew how the voice recordings would be used, including that they would be used for promotion of Lovo as options for the Lovo website and to train the Jenny software. Defendant intended to defraud the voice actor plaintiffs and class. Plaintiffs reasonably relied on these material misrepresentations. Indeed, plaintiffs confirmed on multiple occasions that their voice recordings would only be used for academic and not public purposes. The voice actor plaintiffs and class were damaged by these misrepresentations. The voice actor plaintiffs and class have not been fully compensated for the use of their voices by Lovo and have suffered from the degradation of their services, and they would not have given permission for their voices to be used if they had known the truth. That's the fraud, is them saying, we're going to use this for academic purposes. The fraud is them saying, we're only going to use this as radio tests, whatever they said for Miss Sage. They knew that they were doing something else with it. They presumably knew that they were going to profit off of it at some point, and they decided affirmatively not to do it the right way. 12th cause of action, we're deep in it now. Breach of contract. Plaintiffs Lehrman and Sage each had a contract with defendant by virtue of their agreements to supply audio recordings to defendant Lovo. Lovo's counsel has confirmed that the voice recordings used to create Kyle Snow and Sally Coleman were provided by plaintiffs Lehrman and Sage respectively. Plaintiff Lehrman agreed to provide his recordings to defendant Lovo in May 2020 with the understanding, as Lovo stated, the script and his finished file will be used for research purposes only. After receiving these assurances and reaching this understanding, after 5 days, Mr. Lehrman delivered the requested voice files via Fiverr in May 2020 and was paid $1,200 for the use of those recordings for internal research purposes only. Defendant Lovo agreed to pay for those recordings and not to use them for any commercial purposes. That is, research purposes only. Mr. Lehrman relied on those assurances in providing his recording. Lovo breached the contract with plaintiff Lehrman by using the recording in ways contrary to its express promises and outside the defined agreement. These breaches include using Lehrman's copyrighted recordings to train the generator, using Lehrman's voice to promote, advertise, and sell the Lovo service, and offering Lehrman's voice as a voice option on the Lovo service, including as a default voice. So they are saying the contract is the Fiverr agreement. The Fiverr agreements don't seem to be consistent, definitely don't have any licensing provisions, which it seems is the defense that Lovo has already kind of set itself up for. They're going to have to explain these contradicting messages, and they're going to have to explain why the messages don't match up with what their lawyers are saying now. Plaintiff Sage delivered her recordings to defendant Lovo in 2019, and defendant Lovo paid her $400 for the recordings. Plaintiff Sage agreed to provide her recordings to defendant Lovo with the understanding that if Lovo was to place this order and later down the line decide to use them in broadcast, Lovo would come back and order the appropriate licensing. She specifically mentioned that this did not include licensing. She could have been more explicit about it, but you really don't have to read between the lines too much to note that if the contract is their messages, and what she's saying is, if you want to use this down the line, come back and order appropriate licensing. Defendant Lovo purchased the recording with the understanding and represented that the recordings were test scripts for radio ads. They will not be disclosed externally and will only be consumed internally, so will not require rights of any sort. Ms. Sage relied on that statement in providing her recordings. Lovo breached the contract with plaintiff Sage by using the copyrighted recordings in ways contrary to its express promises and outside the defined agreement. These breaches included using Miss Sage's copyrighted recording and her generated voice as a key part of Lovo's fundraising efforts, including but not limited to the Berkeley Skydeck presentation, using her copyrighted voice to train the generator, using Miss Sage's voice to promote, advertise, and sell the Lovo service, and offering Miss Sage's voice as a voice option for the Lovo service. Had they known that their voice recordings would be used to create AI voices, plaintiffs would not have allowed such uses of their voices, or would have sought greater compensation. Because of defendants' extra contractual uses of their audio recordings, plaintiffs have incurred damages. 13th cause of action is copyright infringement. So this is where I feel a little bit more at home compared to the New York general business law statutes, because I do copyright law. I am not a New York attorney, though. Plaintiff Sage's copyrighted works, the recordings made by Miss Sage and delivered to Lovo in 2019, are original voice recordings containing copyrightable subject matter, for which copyright protection exists under the Copyright Act. Defendant infringed Miss Sage's copyright by using her exact recording in the 2020 Skydeck investor presentation, in pitch meetings with potential investors, and at the 2020 CES Tech Conference. Defendant further infringed Miss Sage's copyright by posting on Lovo's YouTube channel a video of that Skydeck presentation. We've seen screenshots of it throughout this complaint. It says here that presentation continues to be available on Lovo's YouTube channel, and it is linked in the complaint here. Defendant still further infringed Miss Sage's copyright by posting on its YouTube site the January 17th, 2020 video, Lovo, Love Your Voice. That video stated, "In this video you will hear 5 speakers whose voices have been cloned to near perfection. Their tone, accent, and even mannerisms are fully learned by our AI voice system." One of those 5 speakers was Miss Sage and her copyrighted recording. Through defendants' conduct alleged herein, including defendants' reproduction, distribution, public display, and sale of the entirety and portions of the copyrighted works without plaintiff Sage's permission, defendant has directly infringed her exclusive rights in the copyrighted works in violation of Section 501 of the Copyright Act. Defendant's infringing conduct alleged herein was willful and with full knowledge of plaintiff Sage's rights in the copyrighted works, and has enabled defendant to illegally profit therefrom. As a direct and proximate result of defendant's infringing conduct alleged herein, plaintiff Sage has been harmed and is entitled to damages in an amount to be proven at trial. Plaintiff Sage is also entitled to recovery of defendant's profits attributable to defendant's infringing conduct alleged herein, including from any and all sales of the copyrighted work and products incorporating or embodying the copyrighted work, and an accounting of and a constructive trust with respect to such profits. Alternatively, plaintiff Sage is entitled to the maximum statutory damages pursuant to 17 U.S.C. Section 504C for the willful infringing content for each of plaintiff Sage's works that the defendant has infringed. Now, they have a lot of evidence here to show that these guys probably knew that they were infringing, right? They copied their work. They knew that they didn't have a license. They had some kind of agreement, the company did, and they did it anyway. They copied it and used it. And we can get to the other claims of unfair competition, but as far as the using the copyrighted work, it seems pretty straightforward that they took plaintiff Sage, plaintiff Lehrman's work, and they copied it specifically to develop their system without having the rights or licenses to use it to develop their system, right? So that if that is found to be willful, then they can be getting maximum statutory damages here. And we have one more copyright infringement claim. Through defendant's conduct alleged herein, including defendant's reproduction, distribution, public display, and sale of the entirety and portions of the copyrighted works without plaintiff's permission, defendant has directly infringed plaintiff's exclusive rights in the copyrighted works in violation of Section 501 of the Copyright Act. Defendant's infringing conduct alleged herein was willful and with full knowledge of plaintiff's rights in the copyrighted works. Again, they're seeking the profits and maximum statutory damages, attorney's fees. As a direct and proximate result of defendant's infringing conduct alleged herein, plaintiffs has sustained and will continue to sustain substantial, immediate, and irreparable injury, for which there is no adequate remedy at law. On information and belief, unless defendant's infringing conduct is enjoined by this court, defendant will continue to infringe the copyrighted work, Plaintiffs therefore are entitled to preliminary and permanent injunctive relief restraining and enjoining defendants' ongoing infringing conduct. They are seeking an injunction because what they're saying is they're still infringing. Lovo still has this YouTube video up that has Mr. Lehrman's voice in it, actively causing him damage. They're saying that these may still be available for sale. Preliminary and permanent injunctive relief. All right, the 15th cause of action is something that I've been hinting at here. I've been using the word induce. I might have been using the wrong word here. Oh no, here we go. Contributory copyright infringement. Defendant Lovo induced, allowed, and encouraged other third parties to infringe on plaintiffs Lehrman and Sage's copyrighted works. Defendant had a right and ability to supervise the infringing conduct because it knew that plaintiffs' voices were being used for purposes for which plaintiffs did not consent. Defendant Lovo had an obvious and direct financial interest in the infringing conduct because it received profit each time plaintiffs' voices were used to create content. This is what I've been hinting at this whole time that I thought they might be doing, and I actually did not read this ahead. The contributory infringement is from their customers, Lovo customers, buying the software, creating recordings that are identical to Plaintiff Lehrman, Plaintiff Sage's works. Lovo is saying, come on in for a low fee, you can infringe on these persons' rights. And the way that they're going about it, because it is at Lovo's direction, basically, defendant Lovo had an obvious direct financial interest in the infringing conduct because it received profit each time plaintiff's voices were used. So we're seeing that Lovo had a motive, even an incentive to get its customers to infringe on these copyrights. So I'd be curious to see how the court treats this one, this 15th cause of action. You don't often see contributory copyright infringement because you do need to allow and encourage. There's inducing would be, it'd be like if YouTube said, I want you all to upload your favorite movie today. We're not going to do anything about it, you know, regardless of your favorite copyrighted movie today. If they actively allowed and encouraged people to commit copyright infringement on their platform, then YouTube would be held liable, which is why you don't see anybody do this. You don't see platforms telling people to post infringing material. And Lovo is in this kind of unique position where they were profiting by telling people to create infringing material. And so I will have to keep an eye on this. We'll see what the court does with this. 16th cause of action. This is massive. Unfair competition. Let's see. Defendant Lovo has taken the voices and work of plaintiffs Lehrman and Sage and the voice actor class to compete against their own use of their voices in voiceover work. Defendant Lovo has knowingly and willfully misappropriated the work of plaintiffs Lehrman, Sage, and the voice actor class. Defendant has assembled a service which bears so striking a resemblance to the plaintiff's product or service, their voiceover work, that the consuming public would be confused as to the identity of the voiceover work. Accordingly, defendant has misappropriated plaintiff's property rights and commercial advantage in the use of their own voices for voiceover work. Plaintiff's businesses have been harmed by defendant's misappropriation of their product, i.e. their voices. Thank you for watching, or listening rather in this case, since the stream video did not pan out all the way through. Would certainly be making adjustments in the future to accommodate that. If you liked the video, please subscribe, and I hope to hear from you in the comments below.